Chancellor of UK Trucks Claim Ltd and Stellantis N.V.
May it please your lordships, I appear for Man Group, now known as Traton, with Mr. Scott. In order of future appearances, for DAF, the co-appellant, Mr. Pickford KC appears with leading Mr. Grubeck. For the appellant UKTC, Mr. Thompson KC with Mr. Gibson and Ms. Cleary. For the Iveco appellant, Mr. Singler KC leading Mr. White. For the interveners, Mercedes-Benz, formerly Daimler, we have Mr. Harris KC, who appears with Mr. Raymond and Ms. Littlewood. And for the intervener Volvo, we have Mr. Hoskins KC and Mr. Rabinovitz. And finally, for the respondent, RHA, we have Mr. Flynn KC, who leads Mr. Wendt and Ms. Mopford. You will have seen a copy.
Mr. Singlet's here as well.
Yes, I
forgotten him.
Did I forget, Mr. Singlet?
No.
Forgive me. I think I said it.
You did. You did say it.
You will have a copy of the timetable, and the plan is for me to aim to sit down at around 11:40, and Mr. Pickford will then pick up the baton until around 12 o'clock, and after that you will hear from Mr. Thompson. We bring just a single ground of appeal. In its most elementary form, the point of law that it raises can be put as follows. Can a proposed class representative properly represent both persons whose interests lie on one side of an issue and also persons whose interests are in the opposite resolution of that same issue? Or put another way, where you have a proposed class with two groups which have a clear conflict of interest in relation to an issue, can the proposed class representative properly represent both groups in relation to that very issue on which they have the conflict? And we say that respectfully say that the answer to that question is clearly no. The point is one that does arise in this particular case. It has not arisen previously, so far as we are aware, in any of the other collective actions, but it is nevertheless an important point of principle for the entire collective action regime. The context in which it arises is one which, as has been recognised by the Supreme Court in Merrick's, is one in which we have one of the most expansive competition law collective action regimes anywhere in the world. There is no requirement, as there is in the United States, that common issues must predominate over individual issues. There is an ability to establish both damage and liability on an aggregate basis, unlike in Canada. We respectfully submit, however, that even under our broad regime, there are some limits. And one of those limits is that the representative cannot fairly represent a class in relation to a putative common issue where there is a direct and inevitable conflict of interest within major groups within the class in relation to that issue, at least where it is unclear from the outset, which side of the issue the representative is intending to promote.
People who are affected by the potential conflict are the members of the class, aren't they?
That is correct.
Not your client. Your
But-
client is just adventitiously jumping on the road and
Well,
bandwagon.
that-
I'm mixing of metaphor.
My lord, I see that, but I think defendants have a legitimate interest in saying that there are limits to the scope of classes that may bring these collective proceedings. And
theory, as it were, but I'm
yes.
just trying to bottom out who's really affected.
Ultimately, this is a point of law, and you must decide it on the basis of the law, and not who is making the argument in our respectful submission. What I intend to do, with your lordship's permission, is to divide my submissions into three parts. First, I'd like to show you how a conflict does arise in the particular circumstances of this case. Secondly, I'd like to explain the legal bases on which we say that the conflict means that the class, as formulated by the RHA, needs at the very least to be revised. And then finally, I want to address the various points that are made against us in the judgment below and by the RHA in its skeleton argument. And I then intend to hand over to Mr. Pickford, who will deal with any further points on the issues I've covered. And he will also, it's intended, deal with the question of relief. And by relief, I mean, if we're right on this essential issue, what form of order should this court make, particularly in light of the UKTC's rival CPO application? So if I may start then with the existence and nature of the conflict, and I apologise in advance if this part of my submissions may all seem a bit obvious, but nevertheless it's important to go through it because the RHA and their skeleton argument deny that there is even any conflict of interest that exists. They deny the very existence of a conflict of interest. So if I may take you through it with a tooth comb a little. If I could invite you to go, please, to Bundle C, which is the supplemental volume, and it's the third volume of that, at tab 28, please. And you'll see it starts at page 1016. And this is the RHA's application.
Yeah.
And you'll see from the first few paragraphs that the RHA's claim is a follow-on claim based upon the trucks infringement decision, and it is an opt-in claim. And if you go forward, please, to page 1021, you'll see in paragraph 12 that they, as is typical in these cases, that evidence is lodged at the same time. And you see in 12.2 that it refers to an expert report from Dr. Peter Davis, which explains in more detail and addresses in this collective proceedings claim form, that addresses the way in which certain common issues identified in the collective proceedings claim form may suitably be determined on a collective basis. So that's the expert methodology report. And I will need to show you parts of that in momentarily. If you could then please go forward to page 1027. And you'll see paragraph 33, the proposed class. And the proposed class is any person who in the relevant period purchased or leased for road haulage operations new or pre-owned medium or heavy trucks registered in the UK or in the EEA. So it includes both new truck buyers and also pre-owned truck buyers or used truck buyers. And if you go forward, please, to page 1037.
But the essence of that is that the truck was purchased new in the cartel period.
They have two parts to their class: the people that bought it new, and the people who bought it second-hand, the pre-owned.
But the pre-owned means that it was purchased new. Whoever purchased it new, whether that person's a member of the class or not, it was purchased in the cartel period, which is why it was overpriced.
Yes, well, it's yes.
According to them.
According to them,
when it was first purchased.
When it was first purchased by the buyer, but purchased for a second time.
Yeah.
Overall,
No,
if it's pre-owned.
it's a very simple point, Mr. Charles.
Sorry, yes, this is during the relevant period. Yes.
The used buyers are only people who bought trucks which were
Cartelised,
cartelised, if we can put it that way. Originally.
It's actually, I'm not sure that it is necessarily restricted in that way. It's during the relevant period.
So if I bought a vintage truck,
Yes.
I like 50-year-old trucks.
Yes.
During the relevant period, that's in the class, is it?
Well, Mr. Flynn will be able to tell you more, but I think it might be, because I think the theory is that the effect of the cartel on new trucks reduces the supply of new trucks, which might have a general effect on the price of used trucks, not just those that are, if you like, resold.
An umbrella effect. An umbrella effect, a ripple effect.
A supply effect, if you like. But I don't think we need to dwell too much on the.
Okay.
And you'll see when it comes to the methodology, and I don't want to I just don't want to
I mean, the
misstate.
primary way of thinking about it
Yes.
is a truck sold for the first time new during the cartel period, which is then purchased used during the period.
I'm not sure that is how, I don't think they limit themselves in that way.
No, but that's the prime, I mean, that's in a sense the
Paradigm.
That may be the paradigm. That may be a paradigm case, yes, where it's sold once, if you like, in the cartel period, and then sold the second time in the cartel period to a used truck buyer.
Anyway, yeah.
Yes. But the simple point is that the pre-owned truck buyer, the buyer of a pre-owned truck, is buying it. It is a second hand truck. That's the fundamental point. So if one goes to 1037, please, you see in subparagraph 8, the proposed class representative has commissioned an expert methodology report that will be used to predict on a common basis the overcharge suffered in respect of each relevant truck, and therefore enables damages to be calculated at the level of individual proposed class members, taking into account the specific characteristics of the relevant trucks purchased, as well as the circumstances of the proposed class member. This bottom-up approach to calculating damages is consistent with the principle of compensatory damages, enabling the proposed class members to be restored to the position that they would have been in but for the infringement, while also providing a proportionate mechanism for the resolution of this central issue, which is common to the claims of all proposed class members. This is, so just to be clear, this is not a claim, I don't need to think I need to take you to it, but you can also see from paragraphs 49 and 80. This is not a claim that seeks aggregate damages. It doesn't seek a single pot of damages, which it will then decide how to distribute at a later stage. Rather, what they propose to do is to calculate damages, as you've seen, on what's called a bottom-up basis. So what they plan to do is to calculate damages for each truck brought in the relevant period. And they intend to use regression analysis based upon the characteristics of the truck and the characteristics of the purchaser to try and estimate whether there's been an overcharge on that truck, and if so, how much. And then what they plan to do, once they've done that on a per truck basis, is to then add up the damages for each of those trucks that a particular claimant that has opted in has purchased. And that will give the amount that they then need to provide to each claimant. So that's what they mean by it being a bottom-up basis. It's explained more in the expert report we'll come to. Then at 1038, we see the common issues identified. And these are crucial for present purposes. The first one you see that's relevant is 47.6 on page 1038. Whether and to what extent the cartel had an impact on prices paid by road haulage operators for new medium and heavy trucks manufactured by the cartel members, either through the cartel's impact on the EEA or country list prices, or because of other areas on which the cartel members coordinated. So that is the question of whether there is an overcharge, and if so, how much, on new trucks. And then over the page at 47.8, you see whether and to what extent the cartel had an impact on prices paid by road haulage operators for pre-owned heavy and medium and heavy trucks. So two distinct common issues. One is the new truck overcharge and the other is the used truck overcharge. And the critical point is to understand how these interact when it comes to calculating damages for a class. If we look at page 1040,
Can I just ask you about paragraph 49, because
yes,
you described it as a bottom-up. There's a top-down element as well, because you've got to calculate the overcharge at a global level before you then subdivide it into the individual claims.
well, I think the to an extent, but the overcharge is done on a common basis, but I think they anticipate there being different overcharges for potentially for different categories and types of trucks. But yes, you're right. There is a common element of it. But then they then apply it to each truck.
Exactly. It's after that common element you've got to subdivide as between claimants.
Yes.
But if it's separately for new trucks and
Yes,
used trucks,
but,
different
yes,
questions.
and the critical point is, as we'll come on to in a moment, is the regressions are separate. It's a separate calculation for new trucks and for
Yes.
used trucks.
Yes.
Now, in paragraph 51, the RHA notes that it doesn't intend at this stage to propose to have pass-on certified as a common issue, but that one can be a bit confused by that, because what they are speaking of there is supply pass-on, in the sense of a potential increase by the claimants in the price of their own goods and services. There is a more fundamental type of pass-on, which is resale pass-on. So that is the pass-on or the mitigation that occurs by selling on the truck itself to someone else. And if the price at which you sell on your truck is raised by a reason of the infringement, then that mitigates or reduces your loss. Now, it's not spelled out in terms in the claim form that it is proposed for that to be a common issue. But as I'll show you, when we get to the expert evidence, it's clear that that is a common issue. It is actually the same as the issue you see, essentially the same as the one you see in 47.8, which is the existence and extent of any overcharge on pre-owned trucks. So may I then turn, please, to the expert evidence that came with that, and you'll see that in the first supplemental bundle at tab 10.
Sorry, which one?
It's the first supplemental bundle, volume 1 of bundle C, at tab 10. Starts at page 127. Where you see Dr. Davis's report. And if I could invite you to go to page 132.1, just to show you. You see in paragraph 24 that he identifies various subclasses within the class that were then proposed. Now, as it turned out, the tribunal didn't find these type of notional subclasses very helpful and didn't adopt them. But what I want to observe is simply this, that the first 4 of the subclasses all concern various ways of buying or leasing new trucks. And the last 2, E and F, which you see on the top of page 133, they concern pre-owned or used trucks. If you then go forward to page 134.
Just for me, relevant trucks as a defined term is not relevant for this purpose, is it? What is relevant trucks?
It means trucks that fall within the infringement decision. So a particular weight.
So is there a time?
There is a time
limitation built into the definition of relevant trucks?
There is. It's over the period of the.
So the answer to our previous questions might be found in the definition of relevant trucks.
Yes, although one needs to be.
Don't go out of your way. But
no, it is to an extent, but
my vintage truck might not be a relevant truck.
It might not be, but I think it might. I think it might be. I think if it is a pre-owned truck sold within the period, I think it doesn't necessarily have to have been that originally the first sale of that truck does not necessarily have to have been within the period.
Okay.
So I think your vintage truck might be within the definition. But you'll see why in a moment, because of the slightly interesting way, the causal mechanism by which the overcharge might arise on used trucks.
So the infringement period, I think it's referred to in paragraph 3, was covered 1997 to 2011.
Yes, that was cut back, in fact, by the tribunal because there was such an enormous. Initially there was an enormous overhang period after the end of the.
Cut it back from 2019 to 2050.
That's correct. Yes. There was an enormous. That's right. So, if I may then show you page 134, and if I could read, if you could read with me paragraphs 31 and 32. As I explain in detail in section 10, the individual relevant truck level damages are aggregated in a bottom-up approach to the level of a specific proposed class member, simply by adding up the predicted damages for each relevant truck for that proposed class member. Importantly, with this approach, there is no need to separately consider the individual circumstances of each relevant truck procurement or each proposed class member. I propose using transaction-level data to account and control for the quantitative effect of the relevant factors that may impact the overcharge for each proposed subclass. Thus, the regression models I propose supply the framework that will enable me to estimate the individual loss suffered by each proposed class member on a common basis within each proposed subclass. The estimates of individual loss would be based on calculating the average effects of the infringement for proposed subclass members, accounting for the factors that differ across them, such as their observed characteristics, for example, fleet size, the frequency and the number of relevant trucks procured, etc., the manufacturer of the relevant truck, the body type of the relevant truck, the sales channels of the transaction and other transaction-specific factors. The estimate of individual loss would be calculated as the sum of the loss on each relevant truck procured by a proposed subclass member. This means that damages can be awarded that will restore proposed class members to the position they would have been in absent the infringement. So I think that sets out rather more comprehensively what I was describing earlier. And if you go forward to page 135, he then starts to explain why the cartel might have affected the owners, or the purchasers rather, of pre-owned trucks and the two pre-owned truck purchasing subclasses. So he says the other two proposed subclasses arise since some proposed class members purchased pre-owned trucks or sold their new relevant trucks after a period of use. While the EC settlement decision does not extend to the procurement of pre-owned relevant trucks, the prices of pre-owned relevant trucks would potentially have been impacted by the cartel, with a consequent impact on the proposed class members if it is established that there was an overcharge applied to new relevant trucks. For example, any increase in price for new relevant trucks would be expected to reduce the demand for new relevant trucks. This in turn will reduce the supply of pre-owned relevant trucks in future years, and so likely increase the price of pre-owned relevant trucks in future years, all else equal. So this is the complex, somewhat complex causal mechanism that I was seeking to describe, and why I think that the vintage truck might conceivably...
It's a sort of umbrella effect.
It is a sort of umbrella effect.
Yeah.
You're quite right. And he says, I propose a methodology, it goes on, to estimate the cartel effects in the price of pre-owned relevant trucks during the cartel effect period. In doing so, I distinguish between proposed class members who purchased pre-owned relevant trucks on cash price contracts and those who lease them. If you could then go forward in the analysis to page 169.1, please, where you see paragraph 178. And here he continues his analysis. And this is really the crux of it. He says, data from the sample group show that some proposed class members purchased or leased pre-owned relevant trucks, and also that some proposed class members sold their new relevant trucks after a period of use. While the settlement decision doesn't extend to the procurement of pre-owned relevant trucks, it seems likely that the prices of pre-owned relevant trucks would have been impacted by the cartel, with a consequent impact on the proposed class members if it is established that there was an overcharge applied to new relevant trucks. For example, any increase in price for new relevant trucks would be expected to reduce the demand for new relevant trucks. This in turn will reduce the supply of pre-owned relevant trucks and so likely increase the price of pre-owned relevant trucks, all else equal. Then he says this, specifically, A, proposed class members who purchased or leased pre-owned relevant trucks may have suffered damage from an increase in the prices of pre-owned relevant trucks, and or proposed class members who sold their new relevant trucks may have benefited from higher pre-owned prices so that the damages suffered will be reduced. So he's there recognising that the potential for there to have been an increase in the price of pre-owned relevant trucks had two, would have, if it applied, would have two effects on class members. On the one hand, those who had bought pre-owned trucks would have suffered damage because they would have paid more for their trucks. But on the other hand, new truck buyers who on-sold their trucks would have benefited because they would receive from any buyer a greater amount, the amount of the pre-owned truck overcharge. And that, in a nutshell, is the conflict, because the used truck overcharge is damage for a used truck purchaser, but it is a benefit, a reduction in damage for a new truck purchaser.
It all starts from the common platform for starting this analysis is that there was an overcharge of X. Everything
That is fair.
thereafter
No,
then
that's,
varies
that's,
and flexes.
no, that's correct. The starting point is that there must be a new truck overcharge. But then the second issue is, and we don't suggest there's a conflict in relation to that issue, that the conflict comes in relation to the used truck overcharge, because there it's going up for one and correspondingly down for the other.
But little a
Yes.
is not, that's not an issue of conflict, because that's the umbrella effect of the overcharge on new trucks down the line on used trucks. It's not specifically focusing on those used truck purchasers who purchased a truck from somebody who is a new truck purchaser in the same class.
Well, there will be a very, very substantial.
Well, there will be,
Overlap.
but not necessarily is the point.
Well, I think necessarily there will be a very large overlap, because some of those new truck buyers will have unsold in the relevant period, and then
Of course, but
each one.
You told us a moment ago that this class of used truck
Yes.
is not limited to people who bought a used truck from a purchaser who bought a new truck in the cartel period and is therefore a member of the class as a new trucker.
Yes, I think that's correct. But I think that as your lordship rightly said, the paradigm case is where is the central, and I'd say on the fringes there may be.
Yeah, I'm just trying to understand the extent of the alleged conflict.
Yes,
that's all.
but for all intents and purposes, I think one can assume that there will be an overwhelming overlap between the two. And if one, it's actually, one could look at it quite mathematically, because if one goes forward in Dr. Davis's report, at 173.1, he then starts to talk about how he plans to calculate damages from another aspect of the cartel, which relates to the timing of the introduction of Euro emissions. And then at 176, we see his section 10, starting on paragraph 210. And he says, in this section I discuss how the various elements from previous subsections are brought together to calculate damages for the proposed class members. If one looks at paragraph 211, he says the overall methodology has multiple parts, but there is a common methodology within each of the 6 proposed subclasses, with significant elements of the overcharge methodology shared across the entire proposed class. For each proposed subclass, in accordance with my instructions, I have proposed a methodology which allows the quantification of any damages. A, arising from the procurement of new and pre-owned relevant trucks from all truck manufacturers. and B, relating to the pass-through of costs for Euro emissions. And he says, for illustrative purposes, in Table 27, which you see opposite, he says, I present formulae for damages for 3 types of representative transactions, each involving the procurement of a new relevant truck, and which allow for a delay in timing. He says, he then says in 213, I denote the choice of a relevant truck in the factual by lambda, and the choice of relevant truck in the counterfactual by lambda dash. As shown in the table, the formulae differ between the procurement methods. For illustration, the expression in the first row of the table includes 3 components. First, the difference in the payment made to procure the chosen relevant truck in the factual, and that paid to procure the relevant truck chosen in the counterfactual. Second, the difference in the present value of the resale value when the relevant trucks are sold as pre-owned. And third, the difference between and then the fuel and reset R&M costs in the factual and the counterfactual. If you look across at the table that he's referring to, you see the equations, and they look rather daunting to you. They certainly did to me. But they're actually quite straightforward. So the first, if you look at the first row, the first line is simply the new truck overcharge, effectively. The second line is the used truck overcharge, and the third line is effectively any overcharge deriving from the emissions technology collusion. And what is crucial is what you notice at the start of the second line, which is a minus. And what that is saying is that you take away the used truck overcharge when you are calculating the damages to the new truck purchaser. So you are quite literally subtracting from the damages to a new truck purchaser the used truck, the amount of the used truck overcharge.
Well, no, you're not. Well, yes, I mean, but that's, I mean, put slightly differently. And I'll probably get these figures way out, but if your truck, absent the cartel, would have cost 200,000.
Yes.
And let's say because of the cartel new, in fact, it's 220.
Yes.
I thrash it around for 3 years and then I sell it on.
Yes.
For a price which is 50% of what I paid.
Yes.
The question is how much of the overcharge, the 20 that I originally paid when I bought it new, I've managed to pass on to the second-hand buyer.
Yes.
In whatever the price is, 110 on my example. Is it just a linear pass on? For example, 10 of the 20 that I suffered because of the cartel, or something else. And the more I pass on, the less damages I can keep. And as it were, the more the used buyer will be able to claim as part of the the class.
That's right. But the gain to the used, if there is, I think the point maybe, my lord, that I would stress is that the used truck overcharge is a separate calculation.
Yeah, but right? It's just the isn't it just the division of the original overcharge between the new buyer and the used buyer?
Not entirely, because the used buyer overcharge is operates by a separate causal mechanism, but which you've seen, which is the reduction in the supply.
Well, that's a separate.
So it's a separate. So it's somewhat more complex than that. But essentially, my lord, you're right that it comes off the used truck overcharge, comes off the new truck overcharge. Yes, that is correct. But the point is that if you are the used truck buyer, you want your used truck overcharge to be high. If you are a new truck buyer, you want the used truck overcharge to be low, and it's a separate calculation it's not simply that we take the new truck. He's not proposing, oh, we take the new truck overcharge and we halve it. He is saying we have a whole
that's
separate.
the question.
He,
They both want. If you ask them what they both want, as against the manufacturers, they both want the new truck overcharge to be maximised.
That's correct. But then when it comes to the used truck overcharge, they are in diametrically opposite positions.
Correct. So it's like, as I say, they are divided on the division of the spoils on which they are ad idem.
Yes, you could put it that way. But but in this particular case, what is curious about what the RHA are proposing to do is they are proposing to go forward and calculate the used truck overcharge for both of these groups who are in diametrically opposite positions on the issue, on the used truck.
On that issue.
On that issue, correct.
So how small does the issue which divides members of a class have to be before your opposition to the single class disappears?
Well, this is not a small. I mean, I mean, one can say that at a certain point it becomes de minimis, but this is not a de minimis point. This is the used. This is a whole separate common issue that they have identified, which is the used truck overcharge issue. And if I can show you the figures, because it give you a sense of the scale of this. So you can find these in the fourth witness statement of Mr. Burnett, which is in the second supplemental bundle. At tab 23. And if you go to page 913, the figures are presented in paragraph 20. Now, they're somewhat opaquely presented, and you need to do a bit of extrapolation. But in summary, the position is this. First of all, you see in the second sentence of paragraph 20 on page 913 that the actual number of signed up claimant entities, so these effectively claimant groups, currently exceeds 16,500. Of those, about 10,600 purchased used relevant trucks. So that leaves 4,900, or around a third of the class, little more than a third, that only purchased new trucks. So a third of the class only purchased new trucks. He also states that of the 10,600, this is the last sentence of paragraph 20, that of the 10,600 signed up claimants that have purchased used relevant trucks, approximately 60% of those also purchased new relevant trucks. So that, by extrapolation, 40% of those didn't purchase new relevant trucks. So in other words, around 4,240, or a little over 25% of the class, purchased only used trucks and no new trucks. So the long and the short is that you've got a bit over a quarter purchased only used trucks, a bit over a third purchased only new trucks. So combining those two groups together, 60%, or the majority of the class, are either only new truck buyers or only used truck buyers. And correspondingly, 40% of the class purchased both new and used. And you see that 60-40 split confirmed in the CAT's judgment granting permission to appeal at paragraph 15, which for your note is in the core bundle at page 338. So where does that leave us? Well, it leaves us that for most of the class members, 60%, there is an absolutely clear conflict of interest on the used truck overcharge issue. A little under half of that group of 60%, the exclusive used truck buyers, want the used truck overcharge to exist, and they want it to be high. And a little over half of the 60%, the exclusive new truck buyers, want the used truck overcharge not to exist, or if it exists, they want it to be as low as possible. And there's just no getting away from it. Their interests of 60% of the class are diametrically opposed on this issue. Now, of the remaining 40% that bought both used and new, it is fair to observe that some of those may be in an ambiguous position because they may not know in advance of the precise calculation of overcharge where their interest lies. It may all depend on what's the precise overcharge on different types of truck. And that's a point that the tribunal emphasised in their judgment. But it's also fair, in our respectful submission, to observe that for many in that overlap group, it will be quite clear where their interests lie, because some of them will have brought either a clear preponderance of used trucks or a clear preponderance of new trucks. And they will know on which side their bread is buttered on this particular issue. So the fundamental point is that for the clear majority of the class, there is a fundamental conflict of interest on the used truck overcharge issue, which is essentially the same as the resale, can be put as the resale pass-on issue. They're just two sides of the same coin. So those, I wanted just to show you that, and forgive me for taking you through it in a little detail, but that is the factual backdrop. And as you will have gathered, we say that a class representative cannot properly purport to represent groups on both sides of a contentious common issue. And so it can't, in relation to the issue of used truck overcharge, represent the new truck buyers and also the used truck buyers, because their interests are just diametrically opposed. Now, I want to make one point clear about what we are not saying. We are not saying that these claims for new truck buyers and for used truck buyers cannot be brought in collective proceedings. It's a question rather of how they can properly be brought. And our point is simply that new truck buyers and used truck buyers must have separate class representatives, at least in relation to that issue on which they are directly adverse. And that means a separate representative with separate lawyers and experts and so on. And in terms of the statutory scheme, we put our argument on three alternative bases. One of them will do, but we invoke three. First, I don't think it's necessary to take up this statute because I know that this court is very familiar with it. But we say, first of all, that it is not just and reasonable under Rule 78(2)(a) for the RHA to represent a class that includes both used and new truck purchasers in relation to the used truck purchaser issue. In particular, class representative will not be able to fairly and adequately act in the interests of the class members because the class members have got directly conflicting interests on this point. Alternatively, we say under Rule 79(b) that the claims don't raise a common issue on the used truck overcharge. And that's because we say, following the Canadian jurisprudence, that an issue is not common if victory to some members of the class will mean a loss to others in the class. And in the second alternative, we say that under Rule 79(c), that the claims of such purchasers are not suitable for inclusion in a single collective proceedings with a single class representative.
So when you say loss to others in the class, it's not a loss, it's just they get less of the recovery.
Well, if
They're not out of pocket. I mean, it doesn't.
It depends. If I would like to show you a case. I actually was. Well, it is actually a loss to the used truck buyer if there is no used truck overcharge.
But that's a conclusion of fact which the tribunal will arrive at the end of the day on the assumption that it's correct. In ex hypothesise that CAT will form a decision which it believes to be right, reflecting the balance between the new and the used. So you have to say that with separate representation, there will be a real difference between the result the CAT will arrive at on the present basis and what it would arrive at with separate representation. Why would that be the case?
I'm
There's got to be some incremental difference.
My lord, I don't accept that we have to show that there will be a difference, but
There might be.
well, there might be a difference, and there might well be a difference if you don't have half of the class represented effectively on the issue. Instead, you try to meld into with a single representative on an issue where they have got directly conflicting interests. Can I show you a case which I think really does illustrate it very neatly? And it is it's in the bundle at forgive me. It's in the bundle at volume 9 of your authorities bundle at tab 46.
Volume 9.
Volume 9 of your authorities bundle. Tab.
I've got 4.
You've got. Well, forgive me. I was told it had been divided into.
This is Royal Mail you're going to.
Yes, it's Royal Mail indeed. It will, if we could go to tab 46, I think if you have 4, it's probably in volume 3.
That's a volume all to itself.
Does it in your and
Volume.
and you have in volume 9, yes. Just while I'm on the volumes, I should have mentioned. I meant to mention in opening that there have been certain inserts into volume 12 of your authorities bundle at tabs 74 and 75, which are really just the parts of the CAT guide. But if my lords, if you have the DAF, the Royal Mail and DAF judgment, which is at tab 46, at page 1917.
Yeah.
Now, this was a claim in respect to the self-same infringement. But but in this case, the only claim brought in the proceedings was by purchasers of trucks by each of Royal Mail and BT, and solely for new trucks. So there were no used truck buyers claiming in the same proceedings. However, the defendant DAF raised by the defence of mitigation by passing. And one aspect of that was that they said, well, these claimants have resold their trucks to third parties, and as a result of the infringement, they have benefited because the used truck prices have been elevated, and so their damage is reduced. And if you go forward, please, to page 2113. You see paragraph 511. The further mitigation defence put forward by DAF concerns the resale of used trucks by the claimants. As with the complements issue, we refer to this form of pass-on in our section H on the legal test for causation, and it appears to be accepted that the legal test would be satisfied if it is established on the facts that the claimants received higher used truck prices as a result of the overcharge. If the link is established, then the relevant percentage would be offset against the overcharge. It also follows that in principle, the purchasers of the used trucks who have paid higher prices would have a potential claim against DAF because the infringement will have caused the used truck prices to be higher than they would have been in the counterfactual without the infringement. So pausing there, that makes it very clear that the issue of the used truck overcharge and resale pass-on are just two sides of the same coin. And if the persons who had purchased those used trucks from BT or Royal Mail had claimed against DAF, then their claim could have been heard jointly. And in relation to this issue of supply pass-on, any of those used truck buyers would have been adverse to the position of BT and Royal Mail. There would have been a direct conflict of interest. And nevertheless, what the RHA is proposing to do is to say it can act both for those purchasers in the position like the Royal Mails and BTs of this world, and also for the group of persons that Royal Mail and BT sold their trucks onto. And it proposes to represent them both and to litigate on both of their behalves this issue of used truck overcharge, on which they are directly adverse. And if you go to over the page 214, one sees in paragraph 515, you see that the tribunal here identifies two mechanisms by which an overcharge on new trucks could have led to an overcharge on used trucks. Now, the second one, the reduced intertemporal or reduced supply effect, is the same one that Dr. Davis, you will have seen from Dr. Davis. The first one, the immediate or substitution effect, is new to us. And as you will see, if you see in paragraph 516, you see that Mr. Harvey, who is the expert for Royal Mail, he's sceptical about both of these two effects. He says, even though Mr. Harvey agreed that these were two theoretical possibilities, he tested whether each of them might apply in this case, but concluded that the claimants were unlikely to have achieved higher prices for the used trucks they sold as a result of the overcharge. And then one sees, you see below in 518, that Mr. Ward KC, who is the counsel for Royal Mail, refers to two paragraphs of witness evidence, which they say support their case. And if you go over the page to paragraph 520, you see that Professor Navin refers to other factual evidence, namely the decision of the claimants to take the decision to extend the life of their trucks in response to the need to find cost economies after the GFC, in the global financial crisis in 2008. And you see in paragraph 521, again, Professor Navin refers to evidence that's in the public domain from a closely related parallel market. And then in paragraph 523, you see that in relation to the reduced supply effect, Mr. Harvey presents evidence of a low elasticity of demand from new trucks as a whole. It's not clear where that evidence came from, but presumably from the data was obtained from somewhere. And then you see in paragraph 524 that Professor Navin cites evidence from estimates cited in commission decisions to the effect that there is a high elasticity of demand. And then over the page you see paragraph 527 and following, the tribunal turns to Professor Navin's econometric model. And you see in paragraph 528 and following the data that Professor Navin used to try and show a relationship between used and new truck prices. And that data comes both from Royal Mail and from DAF. And then you see in paragraph 533 under the heading, data limitations, you see that there were limitations on the data that was used that the tribunal found undermined the reliability of Professor Navin's econometric analysis, in particular the absence of data from other truck manufacturers and the failure to obtain data on BT. So, and then the tribunal then goes on to discuss the various statistical issues with Professor Navin's analysis. And in paragraph 547, you'll see the conclusion. And the conclusion is that they believe that on the balance of probabilities, DAF did not establish that there was a used truck overcharge at all. And so the resale price, the resale pass-on mitigation defense failed in its entirety. So forgive me for taking you through all of that, but we say that there are a number of points that emerge from it. First of all, the resolution of this issue didn't turn purely on technical econometrics applied to data that was there. It also turned on factual evidence that was adduced and relied on. That factual evidence informed the inherent probabilities and informed the assessment of the statistical evidence. Secondly, it's obvious that that factual evidence needed to be obtained and marshalled by the legal teams on either side and under instruction from their lay clients. I mean, which witnesses a party chooses to call, which documents it obtains and adduces, depend on what side of the case you're on. It's not a neutral exercise. The case also shows that the interpretation and the form of the econometric models are themselves potentially highly contentious, and they're subject, as you would expect, to various permutations and interpretations. And critically, they depend on data. They don't run without data, they're not formed without data. The data is not always just there, off the shelf, pre-packaged for the experts to use. The data has to be obtained. Parties can and do make specific disclosure applications. They make third-party disclosure applications to try and get the relevant data to inform their models and to run their models. And which applications a party makes for specific disclosure or for third-party disclosure of additional data sets depends on which side of an issue you are seeking to promote.
So you say particularly in relation to demand-side elasticity.
Yes.
That's
yes.
the key determinant of the extent of the following.
Exactly, and you see that they rely heavily on factual evidence as well as data. But it's
the same issue
yes.
that we had in McLaren as to how you prove that variable level of pass-on, assuming, because the percentage overcharge there was minuscule
Yes.
relevant to the overall price, so there was an assumed very high degree of zero elasticity at the top, and it all got passed on some way. But here,
Yes, absolutely, because all of these
That's
these models don't just take place in a vacuum. You assess them on the basis of the factual evidence. It's critical, and you have to get the factual evidence from somewhere, and you have to get the data from somewhere. It isn't just all there, and that's what the solicitors and the lay clients are doing in these cases when they're trying to promote their client's case.
I'm assuming it can't be done objectively across two categories. You can't just go on, as it were, to inquire to find the facts.
It's not in our adversarial system. That's just not how it. This is not an inquiry. It's not properly an inquiry. This is in an issue where you have got two sides, absolutely at loggerheads. You can't do that in a neutral way. You can't fairly.
Why? I mean, the two sides here. You've got the manufacturers on one side with the defendants. You've got the claimants who are putting forward what they at least would say was a neutral and objective set of facts about both the overcharge and the pass-on.
But suppose you had, test it this way. Suppose you had in DAF, you had both the used truck, the people that bought from BT and Royal Mail, and you had BT and Royal Mail. No solicitor would think that they could properly represent, in relation to the used truck overcharge issue, both sides of that debate. Because what's a win for one is a loss for the other. And this is the other point that comes out of this, is this is not a sort of, oh well, both sides are going to go away happy necessarily. Because as you see in this case, the issue is capable of being binary, entirely binary. Because in this case, Royal Mail and BT argued for no supply pass-on at all. And the tribunal agreed. So that would, if you write that large in the context of a CPO, that would eliminate the claims of over 4,000 used truck claimant groups in a single stroke. And precisely because Dr. Davis is independent, he can't say properly in advance, oh well, I'm not going to be binary about this, because maybe that's where the data will take him. So I want to briefly, if I may, mention some of the authorities that are relied on by the RHA, and the RHA prays in a Gutman, and we say Gutman.
Can I just ask you, do you say, before you do you say this is a hard jurisdictional bar? or would you say it is a case management question?
No, I say it's a hard jurisdictional bar because I say that you cannot represent both sides on an issue in which both the two sides are directly adverse.
So I'll go back to a question I sort of put rather clumsily to you earlier. If you have two class members whose interests in what I'd call the main point are ad idem, namely getting as much money out of the manufacturers as possible
Yes.
for the cartel effect. But on one of the issues as to division of the spoils between them, they are divided. You say that means that there cannot be a single class representative, a single set of collective proceedings, because you simply can't use, for example, case management techniques to have that discrete, separate sub-point argued.
No, I accept that there may be. It's not really for us as defendants to say how it could be. One could effectively overcome this problem.
Well, I think a moment ago you said, at a slightly earlier point, you said that at least in relation to this issue,
Yes.
there had to be separate representation.
Yes.
From which I deduced that you would accept that if there were separate representation in relation to this issue, the issue raised
Yes.
by paragraph 16(8) or whatever it is,
Yes.
then I've got the wrong paragraph, the other one I
Yes. No.
then that would satisfy the point.
Yes. And I do accept. And I
By
don't.
representation, let's be clear what we're talking about.
Yes.
Representation by lawyers and experts and accountants to argue the point.
Yes. That is correct. And forgive me. Yes, I wasn't trying. I mean, I do accept what.
So the RHA could remain as the class rep, as it were, the umbrella class rep, but for
Yes.
the purpose of this issue,
You need to get a
there has to
separate.
be separate representation
That's
by
correct.
counsel and solicitors,
That-
separate expert.
That is correct. And
See, that's why I said it's a hard jurisdictional bar to the making of a representation order. It doesn't sound like it is. It sounds like it's not a hard jurisdictional bar, but it's something which the class representative will need to think about. I mean, can I give you an example just to ponder on from
yes,
an area I'm slightly more familiar with?
yes,
In insolvency, there's often a sort of first line issue, which is, do certain assets form part of the insolvent estate, or
Yes.
are they owned by somebody else?
yes,
And then there's a second line level issue, which is, as between two creditors of the estate, who has priority over.
yes.
The
all of that,
assets.
yes.
Now, in those sort of circumstances, it's, from recollection, quite regularly the case that you have the same administrator who takes over the company, who fights against the third-party claimant who's trying to take a little chunk out of the estate. But when it comes to the division of what is in the estate,
Yes.
he will step back and appoint two separate teams of lawyers to argue the sub-point on which the two different creditor groups are
Yes,
opposed.
yes,
But it doesn't mean that the administrator can't institute proceedings on behalf of the creditors as a whole, even though the sub-point has to be separately litigated by representatives. And it seems to me at the moment that there shouldn't be have to be two collective proceedings, or indeed you just take the used purchases out of the collective proceedings at all.
yes,
What you do is, provided that the class rep has some form of idea about how, when that issue comes to be addressed, the conflict can be, the two conflicting parties can be represented before the court to make the decision,
yes.
then this
No,
is a
well,
case
I-
management question and not a,
Well, it depends what.
not a jurisdictional
Well, I
question.
think the problem is you have to argue it's a jurisdictional issue, because if it's simply a case management issue, then it's really just for the cat.
No, my lord, if I may I seek to try to set out our position. The CAT has ordered certain common issues. And one of the common issues it's ordered is the used truck overcharge. And it is on its current order, it says the RHA can represent everyone on the used truck overcharge. And we say it cannot do that, and that is jurisdictional. Because you cannot, in relation to an issue where there are two adverse groups within the class, order a single representative. And you can't set up Dr. Davis, which is what they effectively seek to do, as somehow trying to arbitrate or mediate between these two groups. So we do say it is jurisdictional, but it is jurisdictional only, I accept, in relation to that issue, in relation to the used truck.
But if in relation to that issue, the RHA's position were to be, we will instruct separate firms, solicitors and counsel and a new expert to deal with that issue on behalf of the used truck.
It has to go a little further in our submission than just separate solicitors and experts. You have to have a separate representative for those people, because you have to have somebody who can give instructions. And ultimately, you have to have a subclass. Yes, we accept that
subclass rep.
we accept that there would be yes, and we don't say there has to be a completely separate class. We can call it a subclass if you like, but it has to have a separate representative with separate funding, because ultimately these kind of decisions. So if you have, for example, a decision, somebody has to say, do we go out and try to obtain this terribly expensive data set that may support a used truck overcharge?
Because this is where it's
somebody has to give that
instruction. This is where it's
instruction.
said against you, that
Yes.
rather counterintuitively you're arguing for more people to fight against you at greater expense for you. But the reason you're doing it is because you know it will be much more difficult for them to get funding for the used truck buyers.
Well, my lord, there's
I
no.
mean, it's counterintuitive for somebody in your position to say, no, we want more people fighting against us. We really do. We want more lawyers, more experts, more people on the other side of the court from us. We really do.
My lord, I think
It's not the
you
norm.
may be making us out to be more Machiavellian than we are, because if one thinks about it, the issue on used truck overcharge, it may be one on which we don't know at the moment, but it may be one on which we would make common cause with one side or the other. So it's not. For example, it might be the case that from the manufacturer's perspective, it is more beneficial to have a used truck overcharge that's high or none, or it may be more beneficial to have none at all, depending on how the mathematics work out. So it may simply be that in fact we end up making common cause with one or other of the two groups. Just as if you imagine in DAF, for example, in the Royal Mail and DAF case, it may be that if there had been the buyers of the used trucks there, DAF would have been naturally been making common cause with them. So it's not necessarily that you can infer that we're necessarily trying to stymie this action, and there's no evidence to suggest that this action would be stymied. And as you've seen, there are very, very large numbers of claimants who are in the used truck overcharge camp.
See, I understand.
So there isn't really a factual basis on which to say that it would be stymied.
I mean, I understand the difficulty that you identify of somebody trying to divide their own mind up.
Yes.
And as you put it, I think,
Yes.
arbitrate or,
Yes.
or in some way between two groups.
Yes.
But there are ways round that question by, as it were, delegating this particular subpoint
But we
within a class representatives organisation, for example. Why do you need to specify that the funding needs to be different?
Well, because the funding will, because ultimately a lot of these decisions say, do you make an application for data, for additional data, say, will require funding. And there are
But
problems with the
if a funder is
funder
prepared to fund a
effectively.
class representative on the footing that on this particular point, if a funder is prepared to fund a class representative on the basis of a plan which says that on this particular point,
Yes.
there will be two separate hermetically sealed teams within the class representatives organisation dealing with and representing the two rival arguments.
But-
Why does this court or the CAT get involved in that level of granularity, provided it can see the mechanism that will be used to bring that issue fairly before the court?
Well,
Can I just, before you answer, add, and I was just reminding myself, paragraphs 255 and 256 of the CAT's judgment,
yes.
where they effectively address your point and essentially say it's for later. So they say, exercising powers
Yes.
under Rule 85, we could at a later stage, when we've got more evidence
Yes.
and better sight,
Yes.
we could order that the CPO is divided into subclasses between new and used purchases.
Let me address that first, and then I'll see if I can remember the previous question.
Sorry,
but
you moved on script, so.
yes, I can't see anything on this. The answer to that, to the second question, if I may, is that because of the order that the CAT has made, the issue arises now because we are going, as far as we're aware, we're going forward now to a trial in which, as in Royal Mail and DAF, you will have new truck overcharge litigated and used truck overcharge litigated. And the minute that you start making choices about which witnesses to call, what documents to seek to obtain, how you're interacting with your expert, who you're going to cross-examine, all of these questions arise immediately. So I can see that it might be different if the CAT had said, well, we're going to case manage our way out of this. What we're going to do is we're going to have preliminary issue on new truck overcharge, and then we will decide what we do about used truck overcharge in the future. Then I would accept I would be in difficulty, but that's not what the CAT has done. What the CAT has done is to allow this issue, to certify this as a common issue, and to allow it to proceed. Ostensibly, the next step would be a CMC to trial. So we have to come to this court and say, there is absolutely a conflict of interest here, and it has to be addressed now before this matter goes to trial. And in relation to my Lord Justice Snowden's question, we do say that you do require a separate representative because you require somebody to give instructions to the lawyers. The lawyers can't just go off and do what they want. They have to have a client, as it were, to give them some instructions. And they also, they need to have powder and shot in order to, which is the funding, in order to be able to make the necessary applications that they need to make on their client's behalf. So they need to have funding. Because an application for, say, third-party disclosure of a particular data set, it can cost hundreds of thousands of pounds. And if you don't have separate funding, how do you make that decision independently? So we do say that you do require it's not just enough to say, oh, we put in some advisory lawyers, which is what RHA proposed. They said, well, we'll have an advisory team of lawyers and an advisory team of experts. We say, no, that doesn't go far enough. You need to have a separate representative with the full panoply of ordinary advisors, as you would in any adversarial process. If I may, I'm trespassing on my learned friend's time, and if I can briefly try to just run through some additional points.
If you do that, we'll have a break when you've done that.
No, I'm grateful. Goodman. My learned friend, in his skeleton argument for the RHA, preliminated the Goodman case. Now, this raises a completely different type of issue from Goodman. In Goodman, the issue was essentially, does it matter if there are persons within the class who have suffered no loss or who may have in some way even benefited from the infringement? And the answer was, in a nutshell, no, it doesn't, provided you don't claim more than compensatory damages overall in the aggregate. But that is not the issue here. The issue here is not that. It is that there are two groups within the proposed class who stand either to gain or correspondingly to lose from the court's resolution of one of the supposed common issues. And it is a case where the loss to one group in the class can be the victory of the other. as you see very graphically from the Royal Mail and DAF case. And that is the limit under of what is regarded as a common issue under the Canadian jurisprudence. Now, it is right to say that the definition of common issue in the Canadian jurisprudence in many of the provinces is slightly different from the definition in the UK. But the definition in Quebec is very similar. And even in Quebec, you have that limitation that success for new truck buyers cannot be failure for used truck buyers. You cannot be that success for one means failure for the other. And just in the interests of, if I can give you the reference to the relevant case, it's the Vivendi case, which you'll find, I think, in volume 11, but certainly in tab 56 of your bundles. And you'll see that in paragraph 45, and then also made clear that it does apply in Quebec in paragraph 76 to 78. So, my Lord, briefly turning then, if I may, to the judgment, and there are, it's in the core bundle at tab 17. If I could ask you to take it out. And if one goes to page if one goes to page 256, you see it, paragraph 75. The tribunal did seem to recognise the issue because they say in the fourth sentence of paragraph 75, a higher overcharge on used trucks implies a greater level of pass-on of the overcharge on new trucks by way of an enhanced resale or buyback. And if you go forward to page 316, you see in paragraphs 232 to 233, again, to our mind, anyway, seems to recognise the conflict. You see at the last, in paragraph 233, they note, it is in the interests, they say, of those claiming for new trucks to argue that there was little or no or little pass-on, whereas the interest of those claiming for used trucks is precisely the reverse. So they do seem to recognise the conflict. One sees then in 235 to 243, they refer to some of the Canadian jurisprudence, and you see at paragraph 244 that they conclude that there is force in the submissions of the OEMs and the Canadian authorities. And then it comes to its what it says there is two important and distinguishing features. And the first of these is it says, well, these are opt-in proceedings, they say. And they say that here it notes that the interests may diverge on the quantification of pass-on by resale of the truck. And we say, well, it's not that their interests may diverge, their interests do diverge. Certainly for all of those that bought only new trucks, or a clear preponderance of new trucks, and all of those that bought only used trucks or a clear preponderance of used trucks. And they then say, but as the RHA explained, position which it adopts on the level of pass-on for the purposes of the action will be governed by the expert evidence which it receives from Dr. Davis, who will be considering the matter on the data without a predisposition one way or the other. And then it quotes Dr. Davis saying that he doesn't understand how the PCM's different incentives would affect him. Now, we of course don't suggest that Dr. Davis is not independent, but as one can see from the Royal Mail judgment, the issue of resale pass-on or used truck overcharge isn't going to be resolved just by running data that's already been identified into a model that has already been created. it involves the prior collation and preparation of factual evidence. And so it's shot through with potentially controversial choices that depend on what side you're on. There's simply no way of getting around that. And the conflicts will manifest themselves not just in relation to the preparation of factual evidence. There's also, of course, an interaction between the experts and the lay clients and the lawyers, in which they discuss the issues, some factual, some technical, that underlie the conclusions in the draft report. And all of that inevitably depends on what side of the dispute you're on. And when one gets to trial, one can imagine all sorts of impossible issues, because suppose, for example, we adduce factual evidence that is supportive of one side or the other of this issue. Suppose to use my Lord Justice Green's example, we call a witness who suggests that there's a high elasticity of demand. That would be supportive of a higher used truck overcharge. How are the RHA to decide whether to instruct their counsel to cross-examine that witness, to try and undermine that evidence, or not? If they instruct them to undermine it, they will be acting contrary to the interests of the used truck buyers. If they do the opposite, they will be betraying the interests of the new truck buyers. Now, the tribunal's other main argument in paragraph 247 is that you get around this because when they sign on, they give informed consent. And the difficulty here is that it can't be informed consent, because at the point at which you're signing up, the new and the used truck buyers don't know what position Dr. Davis and the RHA will be adopting.
But suppose it's not going to be Dr. Davis adopting a position, but they're told on this issue there are separate teams which have been instructed to represent your particular, or the two particular sides.
That might then be sufficient as long as they had a separate representative, as I said, and separate funding. Yes, we accept that. We've never said, even below, we never said we absolutely insist on two separate classes. We said it doesn't matter whether you call them classes or subclasses, but they have to be genuinely distinct, distinctly represented.
See, what I'm puzzled about is in a different type of situation where you have a as it were, liability phase and a distribution phase.
Yes.
Nobody's ever suggested that the possibility that there may be a second distribution phase as between the class members means that there can't be an initial representation order made with common class representative and common funding, even though you know at the end of the day there may be a squabble between the class members as to who gets exactly what of the collective spoils.
Well, my lord, that may be, and in those sorts of circumstances, if somebody had said, well, we're only going to represent these two groups in relation to the new truck overcharge, if that had been the only common issue, and then they had said, and we will pause at that point, and then we will divide, we would not be here.
Yeah.
But that's not what they did, and we made this point very clear all along. And they didn't adjust. The closest they came to adjusting was to say, well, we'll get them some additional advisors. But that's not what you need. You don't need additional advisors. You need to be separately represented so that the separate groups can have their own a separate representation.
Do you say that has to be added to separate funding and therefore separate orders?
You could possibly do it within the same order as long as there was clearly a separate representative with separate funders, but there does need to be.
So it's got to be two separate funders, you say?
Two separate representatives and two separate funders and two separate lawyers and two separate experts.
So they can't be representatives, but same funders. Different representatives, same funders.
That's correct.
Because if you were, which of course you're not, Machiavellian, you would want there to be two funders because that increases the risk that the litigation collapses. But you're not Machiavellian, so
there's no sign of this particular litigation collapsing.
But it becomes The risk return ratio then is radically altered if there are two funders.
Well, my lord, you have
40% of the class
yeah, sorry.
requires separate representation.
Yes.
And then what about the hybrids, between the 40% hybrid?
Well, that's the other point that is made by the tribunal, which is that there is this overlap, 40% overlap, and what is, if I may just deal with that sort of substantively, because I should deal with it, and what the tribunal says is that even if you have two separate classes or two separate subclasses, they say there will still be some within the class who, as it were, are conflicted, because some of those who have bought new trucks will also have bought used, and some of those that have bought used have also bought new. And the answer to that is very straightforward, which is that if you have two separate representatives, then they know the capacity in which they are, one for new trucks, one for new truck buyers, one for used truck buyers, then they know the capacity in which they are representing their members. They know the new truck representative knows that they are batting for the new truck buyers, and the used truck buyer knows that they are batting for the used truck buyer. And there's no confusion, and everybody knows if they go into that class what side they're going to be on. So even if there is an overlap, even if there are some people in the one class who think, oh well, wouldn't it be better if I lost on this issue, nevertheless there is no actual conflict that infects the way in which they're represented, and that is something that the tribunal simply doesn't seem to grasp, is that if you have a separate representation, then you do get over the problem of trying to represent effectively both sides of the argument.
So it's,
Simply
you say
can't
it's
properly be done.
not permissible, and I'm struggling at the moment to see where jurisdictionally in the statute or anywhere else it says you can't do this. But you say it's not permissible for somebody to be told you will be represented by the RHA whether you bought a new truck, a used truck, or a combination. Save in relation to the used truck overcharge issue, where two separate teams within the RHA, which will operate with a Chinese wall, will instruct different experts and lawyers to represent the two different arguments. And you're saying it's impermissible for people to opt in to such an arrangement.
Well, no, I don't suggest that. I suggest that if you have the separate representation, then that gets over the problem. I think so.
So you can have two teams, two Chinese wall teams within the RHA, and that'll be fine.
Well, not within the RHA. You have to have a separate they have to
Why
appoint.
not?
Why not?
Well, because that doesn't go. It doesn't ensure their independence.
Well, I've
And
just said, I mean, they understand what Chinese walls are. They are told you mustn't, on this issue,
But who is to
engage in cartelist activity with the other team.
But the difficulty is, from whom are they to take instructions? They have to take instructions from somewhere. I'll give the example of, there's a large application that they wish to make, one side or other wish to consider to make for additional data that is extremely expensive. How are they can't go back to the RHA to decide that. They have to have an independent.
No, because in my lord's example,
Yes.
there's a separate team within the RHA which represents the used truck owners. Nothing to do with the team that represents
I see.
on this issue. Nothing
Well,
to do with the team that represents everybody else.
But there would have to be a separate individual, if you like, appointed by the RHA.
Well, that's the
Yeah, who would, and it would be clear that, I mean, one point that I've rather skated over here is that it's acknowledged by the RHA that they have a fiduciary duty to the class, and it's fundamental that you have a fiduciary duty. As I don't need to tell your lordship this, that there should then be no conflict of interest.
Well, you have an undivided loyalty.
Indeed.
But the issue, on this particular issue in advance, the used truck owner is told there is a team within the RHA that will give you their undivided loyalty on this issue.
Well, yes, but they would also have to have a budget. They would also have to have a
And so
funding
if the
to do
funder
that.
comes along and says we're prepared to fund, including 2 teams, separate teams to act on this issue, why does the funder, the funder's just saying we're prepared to stump up,
As needed.
whatever's needed. And if the funder is told in advance this is what's going to happen on this particular issue, we're going to come to you for 2 teams of lawyers, experts, and divided within the RHA, and the funder
I
says,
think,
okay,
yeah.
better that I'm doing it than somebody else completely. What's the problem?
It might be possible to construct something, but you would have to ensure that you had sufficient funding and that the deployment of the funding could be deployed entirely independently.
Well, I'm sure you will shout loud if one of your opponents isn't adequately funded to fight you.
Yes, but the point here is that they need to be fairly funded, if you like, for each other, to fight each other. They can't.
Well,
In my lord's example, in fact, the funder is fully informed in advance that this is what is going to happen, and there will have to be appropriate funding, as it were, for both sides of the argument. And the funder says, "Fine, that's absolutely fine."
The difficulties lie in the incentives of the funder, because the funder's incentive is to seek to maximise its overall recovery, and that might favour one side or the other.
Yeah, but if the funder's told
So,
this is the real world.
Yes.
If the funder is told, the alternatives are either you represent everybody
Yes.
on this basis, and you will have to provide sufficient funding for both sides of the argument, which means at the end of the day you may not get you may not get X%, you'll get X minus 1. The alternative is you only act for 60% of the class.
Yes.
And therefore in that example, you will only get X minus 5.
Yes. Yes.
I think I know which side of the line I'd be going
it's-
if I were the funder.
Yes. Well, my lord, I can see that, but the point is, it does all need to be sorted out very carefully, so that there are no conflicts of interest. And what's been allowed to happen here is it's just proceeding to the next stage without any, and this is jurisdictional, because first of all, this isn't a common issue, properly so called, but certainly not the way the Canadians look at it, because it's one in which,
Where's in the statute or the rules this common issue?
well, it's the definition of it's defined as related, similar or related issues of fact.
On any view, it's a related issue.
Well, it's yes, but
Is it correct?
I say
Similar or related issues of fact or law?
my lord, let me take you where again I skipped over it, but let me take you back to the. There's always a danger in skipping over these things. Could I invite you to take up the first authorities document, tab 3.
The rules.
Yes.
Yeah.
And if you go to page 72, and the principal way we put our case is if you look at page 72, 78, rule 78, subsection 2, is we say first of all you see in 78, 1, that it must be just and reasonable for the applicant to act as a class representative, and 2, it is just and reasonable for the applicant to act as a class representative. So if the tribunal shall consider whether that person would fairly and adequately act in the interests of the class members. And the principal way we say is the RHA cannot fairly and adequately act in the interests of the class members on this issue.
Why not? Because if it's identified that there is a conflict between the class members on a particular issue, but has clearly set out a structure which addresses the conflict and indicates how it will be resolved, why is
Well,
that
okay,
not
no.
creates fair and adequate?
But maybe then it could, but it hasn't.
Right, okay. So that's why I asked you,
Yes.
it seems ages ago,
Yeah,
whether this
forgive
was a
me.
jurisdictional question.
Well,
or a
I say, well,
case management question?
it's a just jurisdictional question in the sense that as things currently stand, we say they do not,
Right.
they cannot, because
that
they
means
have not come forward with
Right.
this, with separate teams and separate
Well,
representatives
on
and
that
so on.
basis, it's not no never, it's just not at the moment.
My lord, I have to accept that. But we do also, you see in 79, you see the requirement that they must raise common issues. And common issues is a defined term on page 68, which means the same, similar or related issues of fact or law.
Yeah.
And there we do pray and aid the Canadian jurisprudence, including in Quebec, where they have very similar definition of common issues. But even in Quebec, as you'll see from the Vivendi case, they do say that the resolution of the issue isn't common, where victory for one means failure for the other. And therefore, on this type of issue, it would not be regarded as common. So, my lords, those are my submissions, and I hope we can. I think you wish to take a short break.
Well, we probably better take a short break, slightly later than normal.
Forgive me for going over time.
Not your fault. Under 5 minutes.
Yes, that's right.
Well,
Sorry, that is.
May it please the court, I appear for TAF, and I would like to address the court on 3 points. I'd like firstly to make some short additional submissions on the nature of the conflict of interest, just a few further points to make clear our position on that. Secondly, then to address the practical implications of that conflict, and then thirdly, very briefly, and if I have time, what we say are the implications of our appeal if we're right, carrying on from the discussion that I was having with my learned friend. So turning to the first of those issues, can we begin, please, in the RHA's reply, which is to be found in the supplementary bundle, volume 2, tab 20, and in particular, page 740, I beg your pardon, 740, and we're at what is paragraph 160B. And about halfway down that paragraph, we see both a concession by the RHA and then its fundamental argument as to why what it's conceded doesn't matter. It says, the total damages awarded to purchasers of relevant new trucks will need to account for any overcharge suffered by purchasers of used relevant trucks, at least to the extent the purchase of the new relevant trucks sold on their trucks and the same relevant trucks are implicated. And broadly speaking, the lower the overcharge suffered by purchasers of used relevant trucks, the higher the overcharge suffered by purchasers of relevant trucks, and vice versa. But that does not of itself amount to a conflict of interest. Why? That's because it's still the case that based on the proposed methodology, the degree of damage suffered by purchasers of new relevant trucks and purchasers of used relevant trucks can be estimated independently of one another. So the key point there is that what they're saying is in the regression analyses that they're proposing to do, there's going to be a regression for the overcharge on new trucks, and there is going to be a separate regression for the overcharge on used trucks. And they assert, well, therefore, there can't be a conflict of interest that really matters here. And that's obviously, in my submission, a bad point by them. Let's assume, in the favour of the RHA, that the overcharge on each is to be calculated entirely separately. So what does that imply? What it means is that those that bought used trucks would have no interest in the outcome of the overcharge. Sorry, those that bought used trucks, I hope I said that, so it was difficult to get it right, would have no interest in the outcome of the overcharge on new trucks, because all they're concerned about is the used trucks overcharge.
Your point is they have to be done sequentially, and the answer to A will govern the answer to B.
Well,
a conflict because those in B will not agree with the regression analysis in A.
Well, no, that isn't my point. So far so good, my lord. We're if we're just focusing on the used truck purchaser, we are content to assume in favour of the RHA at this point in the argument, which we're taking it through in its logical implications. Let's say they are right about this, and let's say they are right that the used truck purchaser doesn't care about the new truck overcharge because they've got their separate regression which simply focuses on used trucks. That's all they care about. So that's point one. What that does not imply is that the new truck purchaser doesn't care about the separate regression for used trucks, because that is critical to their loss, because obviously that's the resale parcel element of their loss. So fine, they get their initial overcharge, but then whatever is decided to be the result of the second regression, that gets knocked off their overcharge. Equally, it's the very basis of the claim for used truck purchasers. So the fact that those are...
And that's why you can't, you say you can't do them separately. They're not separate, they are intertwined.
Indeed, my lord, and I apologise if I misunderstood your question. Right, they are intertwined, but even if they are independent, we don't have to assert that they are not independent. We're happy to take that point and accept it for sake of argument. But even if they are independent, the second issue, the used truck issue, remains absolutely core to both of them, and it pulls in absolutely opposite directions. So the supposed independence doesn't help them.
The point you're making is that the new truck owners will want to be able to pick off points as to why the analysis, the regression analysis in relation to the used truck is wrong or excessive or whatever, or whatever.
Absolutely.
Whereas, of course, the used truck owners will want to maximise the extent to which it's a correct, entirely correct analysis, which isn't open to criticism.
Quite, and it's not just. I mean, it is maximising it, but it's also it's fundamental. It is the entirety of their claim, which is why, with respect, Lord Justice Snowden's analogy, if I suggest, doesn't quite work on these facts, because I think, my lord, what you had in mind is effectively a prior issue that we decide issue one, which is here's the kind of aggregate overcharge, and then we go on to consider subsidiary issues about how it gets divided up. That's not how the RHA are proposing to tackle the issue of used truck overcharge. Their position is that these are independent. They just go, the answer, if you're a used truck purchaser, you just go straight to the regression for used trucks. Forget about what happened in relation to new trucks. We don't care. We just look first and foremost and solely at the used truck regression. So given the way that they're proposing to tackle this issue in their own claim, there isn't a prior issue where you can say, well, fine, we can have the first issue being considered and perhaps they can be jointly represented for that, and then we'll go on to the second one. Insofar as the court was suggesting that actually the right approach is that you need a degree of separation, and we'll come on to how much separation, but let's assume separate lawyers and economists at the very least. That's from the beginning, because there effectively is no prior point. So that's my first submission, which I think it's important is appreciated.
Sorry, are you saying, if there is no new truck overcharge, I can't at the moment understand how the used truck overcharge could succeed.
Well, certainly logically, that would appear to, from a matter of economics, you would stand back and think, well, that result doesn't make a lot of sense. So I imagine if the economists came to that view, they will be scratching their heads and very puzzled. But what Dr. Davies is suggesting, and what the RHA make a virtue of in their reply when explaining that these two things are independent, is that that's I think effectively is a matter of economic theory. I think we can agree, as a matter of economic theory, it would be odd if there was an overcharge on used trucks but no overcharge on new trucks. Common ground. However, as a matter of econometrics, that is the statistical analysis that's going to be undertaken in order to prove the extent of the overcharge, what the RHA is saying is that they're not going to firstly start with a grand overcharge and then subdivide it and work out who who gets the spoils, they're going to have one regression for each, and they make a virtue of that. They say, well, look, they're independent, therefore there's not a problem. I say, fine, they may be independent, doesn't mean there's not a problem.
The problem is only a problem with the used.
That's right. The
There's no
problem
with
is
the new,
all...
because they do have common cause in relation to the new. Both of them are interested in showing as much of an original overcharge as possible.
That is true insofar as they, I mean, from the point of view of the used truck purchaser, what they actually just care about on their econometric approach is that used truck overcharge. Now, I think it would, as I said, as a matter of theory, you would expect if one is greater, the other is greater. And so they may well be looking for evidence that supports their position on used trucks. And that would obviously probably help, some of that evidence may well help the position on new trucks. So there may be some points where what they're looking at goes, helps both of them. But on the fundamental question of used trucks, at that point they have diametrically opposite interests. Okay. And the independence of those points, the independence of the new and the used regressions, doesn't help them. In fact, it's fatal to them.
The way I understand it at the moment, I can't see at the moment any conflict between the purchaser of a used truck and the purchaser of a new truck on the question of the new overcharge. I mean, at worst, the used purchaser is indifferent.
That's correct.
At least he doesn't care how much the new truck overcharge was, because it's really perhaps just a ceiling. I mean, he would care a lot, I suspect, for reasons we've just discussed, if it was zero or close to nothing. But at the end of the day, there's no conflict.
No,
he just wants the new. He could think if the new truck overcharge was larger, it would sort of stand to reason he's likely to be able to establish that the used truck overcharge is higher.
Well,
there may not be an economic metric correlation, but he's not in conflict. I mean, where I understand the potential conflict is over the used truck overcharge, because that will, if you're right, reduce the damages maintainable by the new truck buyer.
That's right, my lord. But as your lordship adverted to, in fact, the used truck buyer may well be somewhat agnostic about the new truck overcharge, at least in its.
Well, he's certainly not going to be arguing that the new truck overcharge should be as small as
No,
possible.
he's not. But his focus, given that these two are said to be independent, is on the second regression, the one that goes straight to the heart of the matter from his point of view. So the used truck purchaser is effectively only interested in one of these two issues. They're interested in the second one, the one that forms the basis of their damages action. The new truck purchaser is interested in both of these issues. Firstly, because they've got to get the new truck overcharge in the first place. Secondly, because they want to then minimise the extent to which any of that gets passed through.
We understand all this. What does it then lead to? Are you saying that cannot be managed internally within a single team? I mean, we understand that where the conflict, this suggested conflict arises. The question is, it's managed. Well, is Mr. Jow right that as a pure point of principle must be addressed and resolved at the outset? Or is it something which the CAT is entitled to case manage on the basis that they recognise the problem, they may have to look at the issue of subclasses, and they may have to require separate representation later on?
Mr. Joel is entirely correct. This is fundamental because the court is being asked to certify a particular proposed claim. There needs to be a blueprint for trial. One needs to understand how that is all going to work. And what they're asking for at the moment is a claim where there is simply one funder. And I'm going to come on to funding in a moment because I'd like to make an additional point about that. There's one funder, there's one representative, there's one set of lawyers, there's one economist. That is the blueprint that they wish, part of the blueprint, that they wish to have the imprimatur of this court to say, yes, that's fine. You may now go ahead and bring that claim. And our point is fundamentally the court cannot do that because in the claim as currently put together and in terms of the construction of how they say it's going to be litigated, there is a conflict of interest that precludes that form of bringing that claim. Now, I agree with the submissions of Mr. Joel that there may be, if there were a different proposal in front of us, and we'll just come on in a moment to just quite how different that proposal would be, that would not prevent used trucks and new trucks both being claimed for in the same proceedings. It's not what we're currently, not what we have before us, and there are a number of ways in which it had to be fundamentally different to the proposal we've currently got. Perhaps now might be a convenient moment to address. I'm not sure. I've got limited time. I know it might be convenient to address the funders point, and then perhaps I can come back if there's anything further on the issues about the nature of the conflict, because I think probably the core point has been made there. So, in relation to the implications of the points that I've been making, one of the issues that the court canvassed with Mr. Joel is our submission that we need a separate funder. Now, let's suppose that the tribunal came to the same conclusion in our proceedings as it did in Royal Mail. So what that would imply in that case is that used truck purchasers don't recover any damages. It all goes to the new truck purchasers. And then comes the question of appeal. Now, whether the RHA appealed against that decision would in all likelihood depend on whether it had the funds to appeal against that decision. So the RHA's decision depends on the funder's decision. The funder would need to choose to fund such an appeal. Now, I don't think I need to take you to it, I'll just give you the reference, but one finds the funding agreement in the bundle, it's supplementary volume 1, tab 8, page 34. Paragraph 10 of that shows us that the funder in this case has complete discretion in regard to the funding of an appeal. So, given that, it would be, in my submission, extremely unlikely that it would be in the funder's interests to pursue such an appeal, because that would almost certainly reduce its overall recovery. Would it be convenient if we go to supplementary volume 1, tab 8?
It's got everything it wants out of the litigation, it doesn't need to appeal.
It's not just got everything it wants out of the litigation, it can only get worse. And the reason why I say that is as follows. There are 2 points that I make to support that. Firstly...
Sorry, I'm struggling with this just a second. Are you saying that it's part of, are you using this to illustrate the problem, or are you saying that it's an inherent part of the certification that the CAT also needs to ensure that before it certifies that any potential appeal against its decision is properly funded?
No, I am not saying that is something that it has to kind of go through mechanically necessarily in every case. What I'm saying is this illustrates, in my submission, very clearly one of the many problems that we have in this case, which is that it's not good enough merely to have different legal teams and have different economists representing. We also need a separate funder, and I'd like to, if that would be of help, just very briefly expand on why I say that's the case. So, from the funder's point of view, we know that the majority of the overall value of the claim is in new trucks. That's hardly surprising. They're obviously the most valuable ones. We see that, just for the court's reference, that's RHA's own skeleton argument, paragraph 31. I don't propose to go to it. So that's point one. And secondly, we also know from the judgment that the greater the damages, the greater the profits of the funders. That's hardly surprising as well. They're effectively taking a cut, and we see that from the judgment at paragraph 229. So if one brings those 2 points together, what we know is that if we had a Royal Mail scenario, that is complete failure of the action in respect of used trucks, that would be payday for the funder, because they can't do better than that. Their interests are most aligned with the new truck purchasers. So they're almost certainly not going to want to fund the appeal. But what about the used truck purchasers themselves? There may be grounds on which perhaps they could appeal. But their interests at this point are not going to be adequately protected by a single class representative with a single funder.
Just pausing there, the reference you gave us is to a paragraph that is completely redacted.
Oh.
Clause 10 is, and quite a lot of what follows is redacted.
Right, so I do apologise, it's not redacted in mine. So I think what has happened here is that there is a version of this bundle that has not been updated for the court. I do apologise. I don't think those behind me are responsible for updating bundles, but obviously collectively it's our job to do that. I think it's probably, well, obviously that's something we'll have to remedy as soon as we can. It is not redacted now, so obviously can't be confidential, and I propose to read out the key clause. It's one sentence, unless Mr. Flynn rises his feet to try to stop me. I don't think he's going to. So for the benefit of the court, it says 10.1, this is under appeals. If Thirium agrees to provide funding in respect of an appeal, there being no obligation on it to do so, then the RHA agrees to instruct the solicitors and counsel to act on the appeal. So the point there is the funder has the discretion as to whether to bring the appeal. That's the point is no more profound than that, but it does have very significant implications for whether the same funder.
So does the funder has discretion to fund an appeal or to bring the appeal?
Well, sorry, to fund an appeal, but there needs to be funding somewhere. There are further provisions that go on to deal with, well, what perhaps the RHA can bring its own appeal and maybe it can find some other funding, but you can see that that is something that simply might not occur, and it would be highly undesirable if we got all the way to the end of the answer from the tribunal on these proceedings, and then suddenly one group found that there was this core issue that it wanted to appeal, and it couldn't.
But then it goes back to my question, which is it part of the CAT's remit when certifying collective proceedings to ensure that an appeal is properly funded, any appeal could also be pursued and funded?
Well,
I mean, suppose you just have a plain vanilla CPO. It's not part of the CAT's remit to say that if the whole CPO was rejected by the CAT, that part of its certification is to ensure that an appeal would be capable of being brought and funded.
Well, in my submission, that is something that the CAT would certainly be entitled to take into account, and us having brought it to the attention of the tribunal and explained that there was an obvious divergence here and a problem. It's not the only problem. I mean, I can give another example. Another example is settlement. The agreement, again, I think it's going to be redacted here, but it implies that Thirium may well have a say in settlement. Unsurprising, that they're the people that are putting up the cash. Again, the exact terms of that settlement may really matter. It might be in Thirium's interest to take a particular sum, which is arrived at in a particular way, that basically sells the interests of the used truck buyers down the river. They might not care about that because they want to just maximise their own return.
Which is the clause that deals with settlement?
It's clause 27.1, I believe, is the one that I was referring to. Yes. Again, unless Mr. Flynn's going to rise to his feet, there's nothing very exciting or controversial or confidential here. It says dispute resolution. The parties agree that in the event of any dispute between Thirium and the claimants relating to settlement of a claim,
That is redacted.
Yeah, that's been.
Yes, but what I'm saying is it's not redacted now. I'm afraid your lordships have an out-of-date bundle where there are excessive redactions. So at one point in these proceedings, my understanding is that confidentiality was claimed over these provisions. It's no longer claimed, which is why we all have something which doesn't have those redactions.
But the cat might say, but I mean, you've got a dispute resolution procedure here, which is reference to an independent case C. And in the case of an appeal, there's no preclusion on a third party, including the RHA, coming in and funding the appeal itself. And for the purpose of appeal, the costs would be very different and the risk-benefit analysis would be very different. What more would the cat ever want to say about things which will be settlement-based or appeal-based?
Well, in my submission, what the cat would like to see and what the cat should see
Was the funder is funded right the way through or required to?
is a funder, essentially a funder who is backing the used trucks claim. Well, I think from the discussions that the court had with my learned friend, we were envisaging that what there might be, at least in relation to some issues, is separation between the legal teams, the economists, and a person within the RHA for used trucks versus new trucks and the overcharge on each. And my point is that in order to make that fully effective and to ensure that there really can't be any problem whereby the used truck purchasers could be disadvantaged, there should also be a separate funder for each of those. Because the funders' incentives very much sit behind those of new truck purchasers, because that is where the bulk of the value of the claim lies. And in my submission, it wouldn't be satisfactory for such a claim to be certified, because for these are two examples, but generally speaking, because it would be a very odd state of affairs for the funder of a particular claim, which we're envisaging is now, there's a separate representation for the used truck stream, for the funder actually to want that bit effectively to fail.
I understand.
That-
I understand that. So the cost of these proceedings to funders goes substantially up on this model to avoid a conflict.
That is correct, my lord. I think that is an implication of, well, if indeed they want to bring back, yes. I don't think we can argue with that, but I mean, we say that is necessary in order to ensure that the jurisdiction is properly exercised.
Yeah. It is what it is, you say.
Yeah. So that then leads me, I think, very briefly to what we seek as a remedy, if we are right. Though, notwithstanding the discussions that the court had with my learned friend about, well, how can we basically, as a practical matter, get through this issue? That is not the proposal that is before this court right now. So if we are correct that there is something fundamentally problematic about the RHA's proposal, this court will need to remit, will need to obviously explain in its judgment what would work, and then it will be for the RHA and the parties to reconsider anything that the RHA comes up with, and we can't prejudice. You know, we might have other concerns. We haven't seen exactly how it's been potentially reformulated. But if they go away and seek to do something else, then we'll obviously have to put our position on that to the tribunal in due course. But that would be that's the appropriate order if we are right, and the court is of the view that, well, it can nonetheless be corrected as long as one takes a sufficient number of steps.
Just out of interest, I was searching for some order or actual terms upon which the cat's certified. Where do I find that?
I'm going to ask someone behind me to find that. Unfortunately, I don't have.
It's in the supplementary bundle.
It's in the new supplementary bundle, I think.
It's draft, and it's not.
Second supplementary.
Is that
The order hasn't been made.
Oh, sorry, the order hasn't yet been made. Unfortunately, I don't actually have my learned junior here today to give me all the right answers. There is a draft, and it's in
Tab 2.
Sorry, so this is an appeal against an order that hasn't been made.
Well, it's an appeal. I mean, I know obviously the general rule principle is that one appeals against the order. There is a judgment which reflects the position that will be adopted once the order is final. And in the CAT, it is often the case, in fact, that there is no separate order. So it is a slight quirk of the way that the CAT often operates, is that one does find oneself appealing in some instances against a judgment, at least effectively the operative part of the judgment, because that's all you get. There are other examples. I can't immediately bring one to mind in name, but they certainly exist. But in essence, in any event, in this case, we have the advantage that there is at least a draft order, which is what was being proposed. I don't think any of this really alters the essence of my submissions, which is that if it is the case that the court is with me on and my learned friend on the fundamental problem, but considers that there is a remedy which involves separation, then the appropriate response to that is that it needs to be remitted, because currently there is no such proposal. There is no separated proposal from the RHA. We obviously can't deal with it on the hoof today. It doesn't exist.
So you're saying that the CAT couldn't envisage the use of its power under Rule 85 to deal with this?
I say that it's a fundamental problem, and the whole of the proceedings and the whole of this argument was predicated on a certain version of what was being sought. If something new is sought, then the parties need an opportunity to consider the new thing that is being sought. It may be that I've, in anticipating where the court might go, I've rushed ahead a little bit, because obviously, as yet, you're to be persuaded. But that's my position.
Okay. Thank you very much.
Thank you.
My Lord, as I think UKTC anticipated, we're running a bit behind the clock already, and the court will appreciate that I have quite a lot to cover, because I have not only ground one but also the other grounds, and I was intending to say something about respondents' notices as well. So I was allocated 2 hours, and I think I'll definitely need that 2 hours. So if I could make a start now, perhaps by addressing head-on the points that your Lordship or your Lordships have made in discussion this morning. Perhaps I could just formally touch on the issue that's just arisen. My understanding, although we're not party to this because formally our case has been dismissed, albeit that order has been stayed pending this appeal, as I understand it, the order's not been agreed primarily because of the notice issue in relation to conflicts. So the whole issue is up in the air, and one can find that at tabs 2 and 3 of the bundle. So there's a draft notice, but as I understand it, it hasn't been agreed because it's not clear or not agreed as to how the conflicts issue should be addressed. So as I understand it, that's where we are, although I'll obviously be corrected because I'm not actually party to that. And we did consider whether we should be asking the CAT to make an order, but it seemed to our position we were probably the last people who should be doing that. So far as the points that have come up during the course of the morning, there was a question raised very early on as to what the interest was of the OEMs in raising this conflicts point. And obviously we have a distinct interest on behalf of our opt-out claimant class And as I think we've made it clear, the entire basis for our class definition and our approach of opt-out aggregate damages was to avoid a conflict and maximise and simplify the recovery on behalf of new truck purchasers. And that remains our position and our commitment. And the composition of our class representative has no other object. That is the basis on which it's being created. Secondly, there's been quite a lot of debate as to whether this is a jurisdictional as against a class management issue. And we say it is clearly a jurisdictional issue because it, for two reasons, it impacts the entire used truck purchasing claim, that the conflict relates to the entire basis for that claim. So it's not a subclass issue that can be dealt with or hived off because it is the basis for the claim. And secondly, it's a point I'll come to in the moment, is that it is also, as put by the RHA, prejudicial to the entire new trucks claim, in that the RHA positively asserts, not only in its pleadings but in its expert evidence, that the new truck damages claims should be discounted by reference to the claims of the used truck purchasers. So it's systematic both in relation to the used and the new truck purchasers. Thirdly, for two reasons, this is a matter for now, not a case management issue to go forwards. We would say that the approach of the Court of Appeal in McLaren would require the CAT to have addressed this matter clearly and proactively at the initial stage, because this is not an incidental issue. This goes to the issue of common issues, to the suitability of the RHA to act in particular for new truck purchasers because of its pleaded case. And thirdly, because of the fiduciary issue that Mr. Jowell mentioned, that it's clear authority going back a long way that where a body is in a fiduciary relationship to its claimants, to its clients, and it finds itself in a position of conflict, then it has to give up acting for one or the other, or possibly both those clients. And that's well established, going right back to the Mothew case. And then finally, and I think this is a matter that was largely raised by my Lord Justice Snowden, that to state the obvious, and it's obviously a point that we raise under our ground 3, the RHA's case is not a claim for aggregate damages for new trucks. And Mr. Pickford has helpfully explained the way in which the RHA proposes to proceed. And I was going to come to that anyway. This is a claim for individual damages, both on behalf of new truck purchasers and on behalf of used truck purchasers, and for that matter, for spot hirers of trucks throughout the cartel period. So it's a very complicated individual analysis. This is not like the Canadian cases, and it's not like our case, in that the RHA is not even trying to assemble an aggregate opt-out award that can then be the subject of distribution at a later stage. They have quite deliberately, both in their pleading and their methodology, adopted an individuated approach that doesn't lend itself to a two-stage issue. On the contrary, it's made it quite clear that at trial, it will be inviting the CAT to calculate individual damages truck by truck. And so that's the RHA's choice. And in my submission, it wasn't open to the CAT, and it's not open to the RHA, to say, wouldn't it have been better if you'd had a two-stage approach like the Canadian approach and sought aggregate damages and then carved it up between new trucks and used trucks. And as Mr. Pickford has pointed out, that's not the basis on which Dr. Davis is proceeding at all. He's working out the used trucks independently by some form of complicated regression analysis, which puts the Royal Mail procedures in the shade. And obviously one of our points, going right back to Dr. Lillico's first report, that confirmed, as we would say, in spectacular fashion in Royal Mail, is that we're extremely sceptical that this elaborate regression methodology can possibly work. But that's perhaps a matter for the respondent's notice issue. If I could just give an outline of what I was proposing to cover, I was going to briefly make some introductory remarks about the claims, and then a summary of the errors of law made by the CAT in its judgment. Hopefully I can cover most of that before the short adjournment. And then I need to deal with ground one, although obviously Mr. Jowl and Mr. Pickford have laid the ground, so I'll take that as briefly as I may, but we do have some distinctive positions on that. And then my ground two, and ground 3 and 4, and the respondent's notice, but we'll have to see how we get on in terms of particularly the last of those. So first of all, the UKTC. When the claim was issued, and it is remarkable to think that it's now almost 5 years ago, in May 2018, it was one of the first applications for a follow-on collective action. It was a comprehensive new trucks direct purchaser collective claim, carefully designed to have no conflicts and one claim per truck, and an opt-out CPO for aggregate damages by the direct purchaser class to be based on industry-wide data for the cartel period with a clearly defined 1-year runoff. The UKTC class representative, as I've said, is an SPV with no other objective than fulfilment of the statutory objective for its class members. It's chaired by a retired judge to ensure fairness between class members, and it has an expert board specifically designed and selected to represent a wide range of truck owners to be supported by a wider consultative committee, and that's spelt out in paragraphs 23 to 25 of the judgment, which is at page 235 to 6 of tab 17 of the core bundle, and in the UKTC amended reply at paragraphs 84 and 92, which is in the supplementary bundle tab 21, pages 807 and 809 to 10. As your lordships are aware, the entire regime is basically focused on the question of the class definition, which determines the scope of the collective proceedings. The UKTC class definition was deliberately designed to have a single claim per new truck registered in the United Kingdom within the cartel period and for 1 year thereafter. And for that purpose, we identified a category of purchasers, but also long leaseholders holding the truck for more than a year, and the intention, which is clear, was to capture the first commercial user of the truck after UK registration and to avoid any conflicts within the class. And we explain that at paragraphs 137 to 144 and 154 to 5 of the reply, which is at pages 824 and 830 of tab 21 of the bundle. Another critical issue to the, particularly our ground 3, is that the majority of the UKTC class are single owners. The great majority have fewer than 10 trucks, and we set that out in our reply, paragraph 139 at table 1, which is at page 825 to 6. So far as the judgment goes, there are 3 critical findings that I rely on, which were accepted by the CAT and not challenged on this appeal. First of all, that UKTC is a suitable class representative, which is paragraphs 23 to 25 of the judgment. Secondly, that minimal changes were required to the class definition in stark contrast with the RHA. And thirdly, and critically, the overcharge to the UKTC direct purchaser opt-out class is in principle a common issue, and that's paragraph 74 at page 256 in the bundle tab 17. So the only issues now raised about the UK application in Daimler and Iveco's respondent's notice are twofold. One, whether the CAT was legally entitled to find, as it did, that Dr. Lillico's proposed expert methodology passed the Microsoft test. And secondly, a more specific issue raised by Daimler. It's not really clear whether others supported, and we would say it was a self-serving argument that the unpleaded pass-on defences that the OEMs profess their intention to run will be so heterogeneous and individuated in nature that they will not raise common issues, as considered by the CAT at section F of its judgment. With respect, we say that there's nothing in either of those points, but if I may, I'll address them briefly and time permits at the end of my submissions, or if not, then I'll address them by way
Would
of
you say
reply.
the short answer to the point is well, certainly the short answer to the first point is it's all a matter for the CAT.
Exactly, no.
It's entirely, it's sort of classic multifactorial assessment by the CAT, of the kind that we've said in previous cases should not be interfered with by this court unless there's an error of law, which there isn't.
Yes, my lord.
That says it all, doesn't it?
Yeah, there are your recent cases, and there's the very first case that I think my Lord Justice Green probably
There's
remembers.
Le Patrol, which Lord Justice Green and I were both in,
Yeah.
and also Goodman, but I think we've made the same point more than once.
Indeed, my lord. In my submission, it is an absolutely hopeless submission.
Right.
And
If that's a good
parcel-
moment, we'll break for lunch.
Thanks.
I can perhaps deal with that point shortly.
Almost.